What happens if a domain name registrant agrees to transfer a disputed domain name after a trademark owner files a complaint under the UDRP? Sometimes, as I explained in the case I'm discussing in this video, the UDRP panelist simply skips over the substantive requirements of the UDRP and orders the domain name to be transferred. Hi, it's Doug Isenberg, and today's case involves a complaint filed under the UDRP, or Uniform Domain Name Dispute Resolution Policy, by a company called Bergman & Bowen against the registrant of the domain name bergmanandbowen.com. The decision was published by the Forum in April 2021. According to the complaint, Bergman & Bowen is a provider of interior design, kitchen design, and cabinetry installation services in Pennsylvania and New Jersey. The company apparently uses the domain name bergmanbowen.com without an ampersand, which is not a permitted character in a domain name, or the word and. Now, in many UDRP cases, the complainant doesn't know the respondent. But in this case, Bergman & Bowen said that it had provided cabinetry and cabinetry installation services through the respondent's business for a number of years before Bergman & Bowen rebranded itself in March 2020. It looks like Bergman & Bowen registered its domain name, bergmanbowen.com, in July 2020. And the respondent registered the disputed domain name, bergmanandbowen.com, about 5 months later. In the UDRP decision, Bergman & Bowen argued that the respondent registered the disputed domain name because of the competitive nature of their work and to disrupt Bergman & Bowen's business and seek commercial gain. On the other hand, the respondent argued that it registered the domain name in connection with the business relationship between the parties. Despite these conflicting positions, though, the decision says that the respondent was ready and willing to transfer the domain name to the complainant. Now, in almost all domain name disputes, the panel must evaluate the UDRP's three-part test to determine the outcome. Specifically, whether the domain name is identical or confusingly similar to a trademark in which the complainant has rights, whether the domain name registrant lacks rights or legitimate interest in it, and whether the domain name was registered and is being used in bad faith. The UDRP system makes clear that the burden of proof is always on the complainant, that is, the trademark owner that filed the case, and that a failure to prove any one of the three elements would result in a decision allowing the current registrant to retain the domain name. But this case was different because, as I said, the domain name registrant agreed in its response or some other communication during the UDRP proceeding to transfer the domain name to Bergman & Bowen. So in a very brief decision, here's what the panel did. It wrote, in a circumstance such as this, where a respondent has not contested the transfer of the domain name, but instead agrees to transfer the domain name to complainant, the panel is authorized to forego the traditional UDRP analysis. This panel, in recognition of the common request of the parties, in the interests of judicial expedience, and in the absence of any aggravating circumstances, has so decided to forego the traditional UDRP analysis and to order an immediate transfer of the bergmanandbowen.com domain name. That's an interesting outcome, and it's one that many other UDRP panels have reached in similar situations. But it's not always what happens when a registrant consents to a transfer. In some cases, UDRP panels still proceed to a decision on the merits. In fact, the WIPO overview provides 5 examples of when it would be appropriate for a panel to disregard a domain name registrant's consent to transfer. First, if the panel finds a broader interest in recording a substantive decision on the merits, such as if the registrant has a pattern of bad faith conduct. Second, if the domain name registrant has expressly disclaimed any bad faith. Third, if the complainant doesn't agree with the transfer and instead has expressed a preference for a recorded decision. Fourth, if there is ambiguity as to the scope of the respondent's consent. And fifth, if there's a question about whether the complainant possesses relevant trademark rights. And those considerations are interesting because although I haven't seen the case file for the Bergman and Bowen dispute, and everything I know about it is from the decision itself, it seems as if the panel could have denied a consent to transfer on at least two of these factors. Because the registrant claimed the domain name was registered in connection with the business relationship between the parties, which goes to both the rights and legitimate interests and bad faith elements of the UDRP, and also because Bergman and Bowen only asserted common law trademark rights, which goes to the first element of the UDRP. In any event, and for whatever reason, the panel here agreed to accept the respondent's consent and ordered the domain name transferred to Bergman and Bowen. Of course, no trademark owner should ever count on this sequence of events, which is why I always draft the strongest possible UDRP complaints for my clients to convince the panel on all three elements of the policy, even if a registrant consents to transfer. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.